Welcome to the Legal Zone. I'm attorney Marcia Mignot, and today's topic is going to be deportation proceedings. Now, we're going to cover the two types of crimes that could end you in deportation proceedings, and the first one is crimes involving moral turpitude. I'm going to run through the list of crimes involving moral turpitude, and then I'm going to also talk about crimes that are considered aggravated felonies under the rule of immigration. The list of crimes involving moral turpitude are murder, involuntary manslaughter, in some cases voluntary manslaughter, rape, spousal abuse, child abuse, incest, kidnapping. Now, those crimes involving moral turpitude are going to be dependent upon your sentence that you are issued at a trial proceedings before a criminal judge. Now, those crimes involving moral turpitude can cause you to be either inadmissible from the United States or deportable from the United States. You might say, what is the difference between inadmissibility and deportability? Inadmissibility is you're not a permanent resident. You're a non-resident of the United States, and you are seeking to become a permanent resident of the United States. That would cause you to be inadmissible. So you would not be eligible to get your permanent resident card because you have a crime involving moral turpitude and that you're not a morally good person. Therefore, we're not going to allow you to become a permanent resident in the United States. Now, deportable is that you already are a permanent resident of the United States, and therefore this crime involving moral turpitude that you have now been convicted of makes you deportable from the United States. Therefore, you're going to be placed in what's called removal proceedings. There are also crimes that are called under the federal law aggravated felonies. And aggravated felonies is a confusing term for a lot of individuals as it pertains to criminal crimes. The reason I say that is because there are people who have misdemeanor charges that they have been convicted of, and because of the sentence or the nature of the crime, it is considered an aggravated felony as it pertains to federal immigration law. So you might say to yourself, wait a minute, I've got a misdemeanor conviction. That can't be a felony because under state law, when I went to court, my criminal defense attorney told me that that was a misdemeanor. So what do you mean I have an aggravated felony? Well, it might be a misdemeanor as it pertains to the state by which you were charged. However, it's an aggravated felony under the laws of immigration because of the sentence or the nature of the crime for which you were charged, pled guilty, and were sentenced and convicted of. Now, let's talk about the difference between why am I inadmissible. You go in and you are charged with an offense that is as simple as, say, an involuntary manslaughter. And an involuntary manslaughter case might be myself and an individual got into a scuffle, and that person in the middle of the scuffle died for whatever reason. They either fell and hit their head and they're deceased. You were charged with voluntary manslaughter and you went to court and you said, you know what, I do not want to run the risk of a jury finding me guilty. I'm going to go ahead and plead guilty, therefore I can avoid it. Now, be careful of pleading guilty despite the fact that you've been told by the state you're not going to be convicted. There is state first offenders that are sometimes available on certain criminal offenses that even though you are not convicted as it pertains to the state law, you're going to be convicted as it pertains to federal immigration law, because the federal immigration law does not recognize state first offender. So you may walk into the courtroom and it may be the day of your life because now you're not having to face a jury and your criminal defense attorney states to you that, hey, I've spoken with the prosecutor, they've decided they're going to offer you a deal. That deal, you're not going to have to go to any prison. If you'll plead guilty today, we'll also do it under the State First Offender Act, and that means you're not going to have a conviction. So if you ever filled out a job application, you can always put on that job application, have you ever been convicted of a felony or convicted of a crime? You can say no. Even if you do that, you raise your right hand, you swear affirm to tell the truth, the whole truth, nothing but the truth, so help you God. You go before that criminal judge, and that criminal judge sentences you. They sentence you to 5 years of probation. Now, the problem you're going to have with that is that immigration is going to consider that an aggravated felony or a crime involving moral turpitude, because a criminal offense could be both. It could be a crime involving moral turpitude, or it could be an aggravated felony. Now, It also could be both. The immigration judge is going to look at your final disposition for your criminal case and make a determination based on immigration federal law as to whether or not you are inadmissible from the United States. So you go before the judge and you say, Judge, my wife has petitioned for me. She is a U.S. citizen. I have 3 U.S. citizen children. I've been living in the United States for approximately 10 years now. I want to become a permanent resident. And the judge is going to look at the law and say, I'm so sorry. Based on the law and based on your final disposition in your criminal matter, you are inadmissible from the United States. So you would never be eligible to get your permanent resident status. Under those circumstances, you would be ordered deported and you would be eventually removed from the United States. If you have that conviction under certain situations, you're going to be a mandatory detained. So there are situations where you might not be allowed to leave the courtroom because we cannot allow you based on law to depart because the law says that the judge has to take you into custody. Now let's talk about deportation. Deportation is for people who already have a permanent resident card. I am a permanent resident. I've pled guilty to this voluntary manslaughter case that you spoke about, attorney, and now I've been placed in deportation proceedings, although I was told by my criminal defense attorney and by the judge in the criminal case that I'm not going to have a conviction on my record. It is still a conviction because, once again, the federal immigration law does not recognize the state first offender. You walk into the courtroom and you say, Judge, I am married to a U.S. citizen. I have 3 U.S. citizen children. Why am I being deported? I've been in this country since I was 2 years of age. I know no other country. I've never lived there. I don't have any family there. Because your offense is considered an aggravated felony, a crime involving moral turpitude, or both, you're going to be deportable from the United States. There are certain circumstances that, although you've been convicted under state law, that you are still eligible for certain waivers to be able to get you out of deportation proceedings. But be very careful about pleading guilty to a criminal charge without consulting with an immigration attorney or without consulting with your criminal defense attorney, assuming that your criminal defense attorney also practices immigration deportation. There are 2 types of immigration. There is application immigration and there's deportation immigration. Be careful that you're consulting with an attorney that actually practices deportation proceedings. Although they're an immigration attorney, you may find that they do not practice in the area of deportation. So if you are facing a deportation before an immigration judge, that individual would not be able to assist you because they're not knowledgeable about what type of relief you might be eligible for before an immigration judge. So you're going to be at a disadvantage. Now, I want to talk about the aggravated felony offenses, the long list of aggravated felony offenses. And the problem you have with aggravated felony offenses is that they're the most severe punishments possible under immigration law. The list of aggravated felonies is a lot longer than the list of crime involving moral turpitude. And keep in mind that a crime can be both, a crime involving moral turpitude and an aggravated felony. Alien smuggling is on the list of aggravated felonies. They're under the federal statute 8 U.S.C. 1101 A43. Attempt to commit an aggravated felony, bribery, and if the term of imprisonment is at least 1 year, burglary, if the term of imprisonment is at least 1 year, child pornography, commercial bribery, if the term of imprisonment is at least 1 year, conspiracy, counterfeiting, crime of violence, destruction, destructive devices, drug offenses, failure to appear, false documents, firearms, forgery, fraud and deceit, illegal reentry, money laundering, murder, national defense, obstruction of justice, perjury, prostitution, ransom demand, rape, receipt of stolen property, revealing identity of undercover agent, RICO, sabotage, sexual abuse of a minor, slavery, tax evasion, theft, trafficking in vehicles, and treason. I'll go into detail regarding aggravated felony in our next segment. And once again, you're watching The Legal Zone. I'm Attorney Marsha Mignot, where the best legal information is always available.